My name is Iris Kanor. I'm from Israel, and I'm honored to chair this panel. And thank you for everyone who is staying to the most interesting panel of this day about rule of law and administrative law. And we have some very critical lectures. And what we want to try to stick to the time frame, because we already passed a little bit of time, so I think if each one of us can concentrate and do it in 15 minutes, is that okay? And then we will have 50. You need, so except our, of course, guest lecture, you might need a little bit more. And then it will be a practice also to thinking how to zoom out and to make it more tight. I will try to keep the time very carefully, and then we will have time for Q&A. I think it's also important that they will get also feedback from the audience, and not only just that we will tell the audience. So our first speaker, Bas, is going to talk about the authoritarian elements of administrative law. I really recommend you to read his, I think it's the last or one of his latest publications about the dual character or administrative character of states in the Hague Journal of Rule of Law. I think it's an excellent article, and we probably hear some of it now. Thank you.
Okay, thank you very much. I want to thank in two ways the organization, first for having me here and giving me the opportunity to exchange ideas and also learn new facts. It was really amazing. And the second thing, I wanted to thank you for promoting me to professor. Which I'm not, but I'm really happy to do it, and I'm looking forward to receiving my monthly salary accordingly. So that's the thing. Thank you very much. So actually my talk is, I think it, well, the organizers knew, but I didn't know, because I didn't know beforehand who was really invited. But I think a lot of what I'm saying ties to what speakers have been saying before. For example, the Ombudsman was talking about all those measures, and those measures are cast in administrative law. There was a discussion about emergency laws in Greece, but the emergency laws themselves, they're executed in administrative law. And even Spiros talked about the discussion, I mean, there was not really a discussion, but the claims of Dicey that there was no rule of law in France, but there turned out to be état de droit in France. But the état de droit and the Rechtsstaat in Germany was actually really a reaction, an attempt to make administrative actions lawful kind of thing. So the Rechtsstaat idea and the rule of law really, and administrative law really tied together. And we'll have a presentation on migration law. Well, that's actually a bit where I'm coming from migration law. And typically the critique by critical scholars when it comes to migration law, that migration, the position of migrants in terms of their legal position is precarious because there are not enough human rights, right? The human rights protection of migrants is insufficient. And I agree in a way, but you know what? The real problem with migrants is that their legal position is predominantly governed by administrative law. There's not so much a problem of not enough human rights, but it's a problem of too much administrative law. Okay, so much for the context. So my research question, I mean the underlying research question idea is the suggestion or the exploration into to what extent does administrative law cater to, promotes, or maybe hampers authoritarian rule of law and illiberal tactics. And by authoritarian rule of law, I mean the idea of targeting and marginalizing. So not eliminating, because we're talking about modern authoritarian rule. So you're not eliminating your opponents, you're marginalizing your opponents through measures cast in a legal form, through administrative law. And then the second thing would be illiberal tactics, and those are where you use administrative law to infringe on rights and liberties, which you could otherwise not do by using normal criminal law or normal private law. And I also learned something through Martin, that I'm not an expert on Polish or Hungarian law at all, and so I took for granted maybe a bit too much the book by Sadurski on Poland's constitutional breakdown. But let's say if we just follow that narrative, it's primarily about problems with the Constitution. We already talked about it, reducing the independence of the judiciary. So if you want to take power as an authoritarian regime, you have to change the Constitution.
Okay? But if you look at what the types of measures they are taking in, for example, Poland, to target and marginalize political opponents, from controlling the media or marginalizing media from opponents, we have many more things, marginalizing civil society, data surveillance of citizens, controlling businesses and the economic sphere, and marginalizing economically opponents. This is all done through administrative law measures. And that's actually not so much discussed about by experts on rule of law and authoritarian regime. And so this made me a bit wonder. So if you want to change a regime, or you want to make it less rule of law, you actually only need apparently then to change or break down the constitution. But there's no need for you to break down administrative law, because administrative law as it is serves your purposes finely. So that will be the test. I know it's a bit provocative, but that's a bit the suggestion. But the thing is, it's easy for us, I mean us in the western part of the EU, to criticize what's happening in Poland and in Hungary. But actually, if you look at it, for example, in my country, in the Netherlands, we also see these types of liberal tactics. And if time allows, I will just stick to one example. So this is, if you can see, this is the Rijksmuseum. So it's the National Museum of the Netherlands. And at that center, just in the there was a demonstration by Extinction Rebellion. And it was not an authorized one, so you should ask the kind of permission, and they did it deliberately to obstruct the traffic. That was the whole point of the demonstration. Now, if you do this, that's a violation of a city regulation, and that's criminal law. And so it's a violation, it's a criminal offense, so there's nothing peculiar about it, etc. And so the mayor sent the police over to find those persons and to written down the facts, and so they could then later on subpoena them to bring them before a court. And after 2 hours or 1 hour, they already arrested, or let's see, fined 10 people or something like that. So that's not enough, and there were more and more people coming to that demonstration. And so the mayor, left-wing, a Green Party, she made use of her emergency powers, which is in the Communal Municipal Act, which was changed because the Netherlands, together with Belgium, organized the European Football Championship in order to arrest hooligans preventively. And so what they did, if you are disturbing the public order, you can collectively hold those persons, detain them, put them in buses, drive them 2 kilometers away from the center, and then you release them. And they call this in Dutch bestuurlijke verplaatsing, so administrative deportation, delocation. And the funny thing is, well, it's not funny, that's a Dutch expression, we always say it's funny, but we mean it. The surprising thing about it is that for the persons concerned, it was okay because you don't have a criminal record. And for the police it was fine because you don't have to do all the administrative things, etc. So it was a really effective measure. Okay, the other example I will skip. So why use administrative law then? Well, the administrative law has this distinctive quality of offering regimes a kind of a legality bonus, while giving them at the same time the leeway to infringe on rights and liberties, which you can normally not do under normal criminal and civil law. And there's this kind of, so I came up with this idea that is a kind of analogy with the dual state. And of course that was described in a different context, I know, and it has a different view, but there's the idea that you can have a system where one part of the system ensures the normal operation of the rule of law. And in the early Nazi German area, there would be the normal civil courts, the normal criminal courts, but also the normal administrative law courts. But then you need a kind of political law, prerogative law, which is the Gestapo and the Sondergerichte, which can always intervene and take apart a matter away from the normal courts. But you need the normal courts to get the normal business of life going on. And the two need each other. Well, at least the prerogative state needs the normal state. This idea, this concept, has been well, of course that's from Franco, but then it's recently been reactivated a bit, this idea, by Jens Meyer-Hendrich. But what he says then, there's a new thing going on with the new modern dual state on the modern authoritarian regimes. It's a bit like, there's not this hierarchy anymore. So they're living really both together. Now what I took from this is this kind of dual state nature. And I will argue that, contrary to what Franco was saying, contrary to Jens Meyer-Hendrich saying, I think administrative law is in of itself creates this kind of dual character. Now, and of course, in order to do that, what did I do? It's very simple. Just to make sure that I was not saying things that people would totally disagree with me in the beginning, I looked at administrative law as it is presented, the characteristics of administrative law in the textbook. So I looked at German administrative law, looked at French administrative law, and I looked at administrative law from other jurisdictions whose language I don't master, so which brought me in the position I had to make the biggest investments for books I ever did for my personal account. That is these things, so thank you very much. And on that basis, I distilled what you have, the characteristics of administrative law, which in and of itself are not contested by the administrative law experts. And so what you have, administrative law offers this kind of normal legal aspect, the legality aspect, and that's at the level of the general administrative laws because they are enacted by democratically elected bodies, or they are enacted by bodies that are at least controlled by democratic elected bodies. And then the individual administrative decision, for example, a building permit, that has to respect the principle of legality, internal legality and external legality. So it must be in compliance with the statutes, it's not ultra vires, but there are also lots of other rules which it should respect. So there you have the legality aspect. And then when it comes to judicial review, in most jurisdictions now, almost any decision, act, will be reviewable by a court. And it's easy access, it's not that expensive to go to an administrative law court. And typically the judges, at least on paper, do a full review of, they look at all the facts, the relevant facts, and they look at all points of law. And they're very grounds of review. So it's not only do you have the competence, but also there are principles of good administration. So there are many things. And if you win a case, typically the type of remedy you get for an administrative law court is typically better than for a civil law court. So these are the good things. That gives us this law-like aspect. But then there's the other side of the equation. You have, let's say, the prerogative state elements. And that is that these general administrative laws, think about Alien Acts, think about Social Security Acts. They typically are able to categorize people, to make relevant legal categories of peoples, which are not based on their particular behavior, but on ascriptive qualities. They can be benign, like income, or health condition, or age, postal code. But they can also use in not different ways, these techniques, right? And then at the level of the individual administrative decision, think about the permits, etc., it has always the presumption of legality. So when the administration makes a decision, it's deemed to be legally valid, lawful, as of the moment it's taken, until the moment the administration withdraws that decision, or it's annulled by a court. So at the meantime, you have to respect it, you have to obey it, you have to comply with it, and the administration also has to implement it. And it can execute it directly. And even with force. So in the civil law or criminal law, you actually have to see a court before you can actually act. And the essence of administrative law, you have this privilege of execution. Now, of course, as a citizen in most jurisdictions, you can ask suspension of execution, but then you first have to go to court. And in certain conditions, you even can do this. That's a bit difficult. And then finally, at the level of judicial review, there's, of course, the notion of judicial deference. The meaning that the court doesn't make an own decision or makes its own judgment on a particular matter of the element of the case, but relies on the judgment of the administration. That will be when there's policy discretion. I think that's a legitimate and an obvious one, and I agree with it, so I don't contest it. But it also happens at the level of fact-finding, with a notable exception, at least on paper, but lawyers confirm you also in practice, with Germany, where there you see the courts do not have this huge judicial deference to fact-finding compared to other jurisdictions. How much time do I have? 10 minutes. 10 minutes. Okay. Okay. Well, actually, then I'm almost. Then I just want to have one more slide. So these are. So the elements here, you can draw them. You can get them from the textbooks. But if you combine them, you have this possibility of committing illiberal tactics thanks to administrative law. Now, what is the way out? Say it again?
No, that's important. I will take the last one.
Okay. I still have time. No, I have time, so let's wait. I take time. Okay, sorry. No, I'll give you the time. Okay, I will. We'll make. So one answer is not the Hayekian answer or the neoliberal answer, in my view, is okay, we should unwind the administrative state. So if you want to have freedom and rights, respect of rights and liberties, just get rid of this administrative state. No, I don't think empirically that's simply not founded. You have, let's say, weak or small administrative states, or simply weak states that can just as well and do just as well use illiberal tactics or turn into an authoritarian rule of law, regardless of the fact that they are weak and small. What I do think that should be done is, and that's actually for people here in this type of audience, I think we should really, jurists, and especially administrative lawyers, should start reconsidering again and examining really properly what it means, this judicial deference to fact-finding, and ask ourselves, why did we have it in the first place? And now the typical rationale for judicial deference to fact-finding is threefold. It is the administration has more expertise with the facts than the judges. And the expertise is for different reasons. One is a very obvious one, proximity. They are there. They're just dealing with the case. They can even visit the building where they want to issue the permit, and they see the citizens. So this is proximity. But they also may have expertise because they're doing lots of permits. And courts are only dealing with the permits that got where people want to object against the refusal, etc. So they only get the problems. And some of them are trained for it, either vocational on the job or engineers, etc. And the judges aren't. And there's a final, and that's, I think, to my opinion, the only valid reason. It's cost effective, right? If you want to have the court to redo it over again, that's expensive. Okay. So, but my view, we should reconsider those rationale if they really apply, if that's what we want. And the final one would be, but that's, I think, a lesser concern for me, is a bit this privilege of execution. But that's maybe more tailored to the Dutch and Belgian situation, where I think in many cases when the administration makes a decision where, for example, they can reclaim from a simple household 80,000 euros and can immediately execute it, and then later on, 1 year later, it turns out that they were wrong, but the family got bankrupt and the children got taken out of the home because the family totally broke down. I think that would have helped if they would not have executed it immediately. And so I think we should reconsider in what situations do we want to have this privilege of execution. Yeah, that's actually basically clear. I want to keep it there.
Thank you so much. So he's there. Okay, so we... Really sorry about the fun. So, Cosmin, can you hear me?
Up, just a second.
I'm really...
Hello, hi everyone.
Hi, Cosmin, how are you?
Hi, fine, how are you?
So we meet together. We met yesterday already. So we meet together, and Cosmin will present us. He will deconstruct the notion of emergency, I think, and what is it? Emergency and
exception.
And exceptional. So we often think about emergency and exceptional situations together. I think he wants to deconstruct that. He wants to do it as a theoretical perspective. And all that, Cosmin, because we are already lagging behind, as you probably noticed, and it's our fault. But if you can do that in 15 minutes, that will be great.
Okay, good.
Thank you so much.
That's going to be a challenge. I'm going to share my presentation with you. Basically, what I want to talk about is to kind of discuss a bit about emergency, exception, and legality. So here you have a photo from 22nd of December, I think it's in Romania. I was like one of those children. And in that morning, it was, I recall it quite vividly, that there was a state of emergency which has been declared over the whole territory of the country. And what happened after that, the television broadcasting stopped, and we had at 12 o'clock, that was at around 10 o'clock, at 12 o'clock, we had the revolution, yeah, which was announced. So for me, it's something which stayed with me quite a lot. Time, this sort of an idea that there is a state of emergency which is being declared, and just after that, there's nothing which happens. And sort of, you know, the constitutional system comes to a sort of a standstill. And I think it's something which is quite marked me quite a lot. Now, what I'm going to talk to you about, it's a sort of a short or a sort of an attempt to answer to, let's put it this way, a sort of a criticism that you know, or a sort of a question that we've got when we launched this book that I've co-edited with my colleagues and friends, Gian Giacomo Fusco from the Kent University and Simon Levis from the Open University. And in this book, we always we try to bring more context into the concept of exception. And we had, when we had the book launch, the discussants, Dr. Leila Brännström from Lund and Professor Dracopoulou from Kent, they said, well, actually, it's very interesting what you've done, but you don't engage much with emergency. And why? And then I thought that, you know, for me, it was something which was quite clear in my mind that emergency and exception are something which are things which are quite different. So after that, I tried to think of further into that direction. And basically what I'm trying to say is that, you know, I think, you know, this is just as a mean of introduction for the time being, is that, you know, we know more or less what emergency means within constitutional theory. And we have this sort of an idea that emergency basically, you know, we can find it in constitutional theory, we can find it in international human rights law. And we have, for instance, as a matter of doctrinal doctrinal position we have in the Paris minimum standards related to the public emergency. I suppose that you have discussed about this sort of things. Then you would have also Article 15 of the European Convention of Human Rights, which basically they offer this idea that emergency is something which can be limited. Yeah, it can be limited through either proportional, it should be proportionate, and it is a sort of a response or a state or an institutional response to crisis, which is limited, which is limited either ratione materia, or it is limited through various forms of proportionality. Now, you also know that emergency in constitutional theory builds on some sort of a consensus that it came from a Roman model. Yeah, the Roman model of dictatorship. You have full powers that once they are conferred upon the dictator, they would become a sort of an absolute ruler. And then the whole idea behind emergency is that the entire purpose of declaring a state of emergency is to enable powers that are not ordinarily permissible under the constraints of the Constitution. However, this doesn't mean that, and it is precisely, I think it is part of the concept of emergency, the fact that actually it knows limits. And it knows limits, this means that rights are going to be restored, and once the crisis resumes, the rights are going to disappear, the rights are going to be restored, the legal processes are going to be resumed. So it is just a sort of a moment within the life of our constitutional system. So, but I wanted to go a bit deeper than that and to think, or to try to think a bit about what does it tell us about the status of legality? Because from my point of view, you see within or behind this position, which is the let's put it this way, like the paradigmatic position that we adopt, we see that we have a sort of a specific view of legality. And I'm going to try to explain what I mean by legality, and we are going to see through the end of the presentation. I think you're going to get a bit more what I understand by that. And basically, you have a particular view of what law is and how it should act. And what I want to say is that basically we tend to understand the emergency as being essentially conservative. Yeah, so basically the executive is not permitted to use emergency powers in order to make permanent changes, for instance, within the legal system. And behind it, we're finding ultimately a vision which is grounded within the identity thesis, I would say, that the fact that the state is a legal system, yeah, so that there is nothing, the state is a legal system. There isn't anything between the state and the law, yeah. No, that's nothing, no gap, yeah, which would go towards the traditional Kelsenian position. Now, if we're looking, and I come here now as wearing the hat of legal historian, I think that this is something quite problematic in many respects, because if we're looking at the history of the uses of emergency, and I'm just going to use the example of Romania, and we can discuss whether this is a paradigmatic example or not. You see that actually after an emergency, some serious things happen. Yeah, sometimes there might not be serious things that are going to happen, but actually emergency, it's always related, or the declaration of emergency, it's always related to some important moments within the life of the polity. Yeah, so either you have a social crisis like you had back in the 1930s, either you have some form of serious problem like we had with terrorism at various points in time after 2001, and there are some sort of signals that things are shifting, are moving, and so on and so forth. Okay, how do I do with time? Oh, I still have about 6 minutes. Yeah. Now, what I say, I mean, my idea is that emergency presupposes as a concept necessarily the fiction of the stability of legality. So it is founded itself on an idea that legality is something which is stable. It's something which is not going to change. Now, and I think it is parasitic upon this notion that legality is not shifting. It's something which is there to stay, and well, actually, you change the law through its own procedures. Yeah, and we can think here of Luhmann. We can think here of various forms through which we try to understand the law as something which cannot be changed otherwise than by its own mechanisms. Now, I think that exception is something quite different. And, exception as a concept, it has been widely discussed by Giorgio Agamben, and that's where I come from, at the very beginning of my PhD thesis, I was very much interested in the work of Giorgio Agamben. And obviously, to some extent, that we can discuss about that, Giorgio Agamben, he sort of reshuffles a bit the Schmittian concept of exception. And, we can go on and say that actually there isn't any difference between emergency and exception, because at the end of the day, it's the same thing. It's Ausnahmezustand. But if we're looking at political theology, in political theology, Carl Schmitt makes it quite clear that basically the exception is to be understood to refer to a general concept in the theory of the state, and not merely to a construct applied to any emergency decree or state of siege. Yeah, and actually he emphasizes that basically the exception is a sort of a hidden nomos of legality. It's something which is always there. Now, this brings me to the following idea, that at the end of the day, what we're dealing with is a different view of legality. Yeah? So legality, which is something that is shifting. It is constantly shifting, and it is constantly related to some form of, political sovereign. It is an expression of a political sovereign behind it. Yeah, so in this way, I think, in many respects, one could simply say that basically exception is a sort of a political concept, or it is a concept in which it rests on a political theory, fundamentally, because, what Schmitt would put forward, it wouldn't be necessarily a legal theory, but rather a political theory. And he's not the only one who would do things like that. So, for instance, John Austin would say more or less the same thing. Now, why I think this is sort of important, and why I sort of emphasize this sort of distinction between the two, and we can discuss this a bit further, is because if we're going to bring together, I think my main point here is that actually constitutional theorists, they shied away from reading Agamben or taking Agamben seriously, because he has his own vision, his own perspective on things, which is basically he puts forward a sort of a philosophical concepts that he brings from the exception. But I think it would be quite useful to take a look into that direction in order to explain some of the paradoxes of emergency. Like one of them that it is kind of constantly highlighted by Alan Green is that sort of an idea of a permanent state of emergency. Yeah? And the permanent state of emergency under the particular paradigm of constitutional emergency doesn't really make a lot of sense because, well, emergency by definition, if we recall at the first in the first discussion and in the first slides, basically emergency by definition is something which is temporarily limited, or it knows temporal limits. But on the other hand, I also feel that people or scholars who are coming, as I am coming from, let's say, law and critique, so not critical legal studies, but law and critique, would benefit quite a lot, and I think that was perhaps the point of criticism for our book, would benefit quite a lot to take emergency into more seriously, and to look into the history of emergency and to offer it that grounding. And I think in order to finish, I think that basically what we see here, it is a sort of a theoretical disagreement, which is sort of revelatory for a disagreement, I mean, for the status of legality, basically. I think that we would be able to take a look at, if we're taking both emergency and exception, and we're trying to read them together, I think we would be able to understand that basically legality is something which is shifting, which is moving. And it is something which looks a bit like in this photo, or within the words of Walter Benjamin, who also wrote quite a lot on exception, actually. Basically, we could look at our legal documents, at our constitutions as being some sort of monuments, which are ruins before disappearing already. Because what we get with this sort of vision of legality, we get a sort of a vision of legality which is constantly shifting and which can disappear. And I think this is quite important for the debates that we have nowadays about the rise of populism, about all the concerns that we have and so on and so forth. And it is the fact that basically we can discuss quite a lot about the importance of our legal artifacts, but our legal artifacts already themselves, they contain their own ruin. We can look at them as being already ruins in a way or another. So I think that this is something, I mean, that's where I want to go with this sort of presentation. So I really hope that I was
Thank you so much.
brief enough. I'm not sure whether I was clear enough, but yes, if you want to ask me questions, I'm happy to answer them.
So we will postpone the questions to the end of the session, but stay with us, because I think now we were going to have a lecture from our host, and I think he's standing in some contrast with you, so although probably he will explain better. So Tudor, the floor is yours.
So I'm afraid that this concept, meta-norm, as I call it, of rule of law, yes, exactly, can become a self-devouring concept. What do I mean by that? That it can go against its very foundations. And I took a concrete example. Our legislation on public integrity was EU-inspired, if not imposed, in the pre-accession period. So we defined for the first time, not in 2010, but in 2006, 2007, we defined for the first time incompatibilities. So interdiction to hold two positions. Conflict of interest, we know what is that. And control of wealth on public officials. these are disciplinary liabilities following the deeds that I mentioned. So when you are found guilty of one of these, you support a main sanction, which can go up to dismissal from the office, and then a complementary sanction. And the complementary sanction was the prohibition to hold the same elected public office for 3 years from the termination of mandate. As I mentioned before, the Romanian law dealing with public integrity is transposing, is implementing EU law. The decision on cooperation and verification mechanism, which was the embryonic form of the rule of law mechanism from today. And on benchmark 2 of this European Commission decision, we have established an integrity agency with responsibility for verifying assets, incompatibility, conflicts of interests, and for issuing mandatory decisions on the basis of which dissuasive sanctions can be taken. As the European Court of Justice ruled a bit later, several years later, these are compulsory obligations for Romania. On the other part, if we are looking to the rule of law checklist from Venice Commission, one of the requirements is forcibility of law, which means the law has to be foreseeable as to its effects and must be formulated with sufficient precision and clarity, with reference to the relevant case law of the European Court of Human Rights, first case, Sunday Times. When confronted now, we will check what was the reaction of different courts, internal and international, regarding this complementary section of 3-year prohibition to hold public office. First of all, Constitutional Court of Romania. So the claimant invoked unconstitutionality of this provision based on unclarity, but the Constitutional Court decided in a way which I call boomerang effect. So the claimant said, it is unclear, so don't apply it to me. It's contrary to the Constitution. The Constitutional Court said the prohibition refers to the same office. So you cannot hold the same office for 3 years. But by a teleological extensive interpretation, means all elected public offices. So we have here, as I call it, negative extensive teleological interpretation, which is something rather unusual, because when international courts mainly use teleological interpretation, they are doing it in the favor of human rights, not contrary to them, except for the Nazi regime, which was Nazi court, which were doing the opposite. Yes. And the prohibition was, by this interpretation, transformed in the restriction to the right to be elected. Because if you cover all elected position, then you affect the essence of the right, like the European Court would say. Another line of decisions where the claimants pleaded that the prohibition is a restriction to fundamental rights and it's identical to a criminal penalty. In every legislation, in Romania too, we have this complementary criminal sanction that you cannot hold public office, elected public office, for a certain period. Our Constitutional Court issued the distinctiveness theory. So they say this prohibition is a sanction of a distinct legal nature from the criminal penalty, without explaining why. And here I think it's incident the line of jurisprudence of the European Court of Human Rights regarding the criminal nature of administrative sanctions, the jurisprudence Engel and others. And even more curious, I would say, prohibition is not a restriction to fundamental rights, but a guarantee. A guarantee of a nature to confer an uncontested moral authority to the holder. The issue was raised also before the Strasbourg Court in case Manta and others against Romania, but the European Court, the Strasbourg Court, didn't want to enter in this discussion, especially because there was no clear from the 14th application of the sanctions were imposed at the national level to the applicants, and they declared the requests inadmissible based on the fact that the criminal limbo of Article 6 was not applicable. Lastly, there is a case pending before the European Court of Justice in Luxembourg, referred by a Court of Appeal Timișoara, which is trying to clarify if this prohibition is criminal in the sense of Article 6 from European Convention, and therefore proportionality of penalties guaranteed by the Article 49 from the Charter, from the EU Charter, this time applies. Then, if this prohibition is contrary to the proportionality article, and if this kind of application ope legis of the prohibition violates rights guaranteed by the Charter, like right to work and the right to an effective remedy. The case is pending. We are waiting for the conclusions of the Advocate General, and the judgment will be expected next year. On the other part, the jurisprudence of the Luxembourg Court on proportionality of sanctions is, I would say, very clear, in the sense the EU law opposes to this kind of fixed penalties that cannot be applied proportional. There is another aspect regarding this prohibition, namely the duration of it, and this has to be interpreted in relation with the duration of the political mandate in Romania, which is usually 4 years for local authorities and members of parliament, and 5 years for the president and the members of European Parliament. So, depending on the starting point of this sanction, which starting point being the moment when the sanction became final. So if wasn't contested, then in 15 days. If was contested, after a final judgment from the court. And in this diagram, we can see that actually this kind of sanction, it can go from the moment when it starts up to 5, 6, or even 7 years. Because it will last only 3 years. If it will start, you got it. Exactly.
But if it's in the end, it's another cycle.
Yeah. So, another unpredictability about this prohibition is duration, because the moment when the sanction becomes final is not under anyone's control. And this comes in conflict with the requirements set by the Venice Commission regarding the rule of law checklist, regarding the quality of legislation. Thank you.
Thank you for keeping the time, so nice of you. And for this interesting lecture, I will have another question later on, but now I finally give the floor to our last speaker of today, Silvio, about rule of law and immigration. Thank you.
Thank you. This is on, okay? First of all, allow me to say that it's a great honor and a privilege for me to participate at this conference. I would like to congratulate all my previous speakers for the extremely interesting topics that were approached so far, and in my opinion, for their flawless presentations. I would also like to thank everyone involved in organizing, but also everyone who is still attending this event at this time. My name is Silvio, I'm a police officer, and in the next following minutes, I'll try to present you one of the detrimental effects of the pandemics, the echo of flight suspension in immigration law, and more particularly, the effects regarding public custody. That's what I'm going to present you today, the effects of the pandemics on public custody. It is already a known fact that during the pandemics, many passenger flights were suspended, situation caused by the border restrictions inflicted by all states in an attempt to reduce the spread of the COVID-19 virus. What is the connection between the suspension of flights and public custody? In order to present this bond, I will speak about the foreign citizens who have arrived from third countries and on whose names have been issued return decisions. The hypothesis, which I'll comment from, is as follows: X, a person which we'll call X, a third country national unlawfully crossed or attempted to cross the border, being caught staying illegally. Consequently, a return decision has been issued on his or her behalf. This return decision could not be conducted within the 30-day period ordered by the ordinance of the prosecutor's office attached to the Bucharest Court of Appeal, due to the fact that some passenger flights have been suspended, notwithstanding all the other formalities have been completed. Regarding these special terms that I have mentioned, according to Directive 2008 per 115 of the European Parliament and the Council on common standards and procedures in member states for returning illegally staying third country nationals, a third country national is a person who is not a citizen of the Union and who is not a person enjoying the community right of free movement. Illegal stay means the presence on the territory of a member state of a third country national who does not fulfill or no longer fulfills the conditions of entry, stay, or residence in that member state. Voluntary departure means the compliance with the obligation to return within the time limit fixed for that person, for that purpose in the return decision. And the return decision is the administrative or decision or act stating or declaring the state of a third country national to be illegal and imposing or stating an obligation to return. I must mention that according to the government's emergency ordinance number 194 from 2002 regarding the regime of foreigners in Romania that transposed the aforementioned directives provisions, foreigner means a person who does not have Romanian citizenship, the citizenship of another member state of the European Union or the European Economic Area, or the citizenship of the Swiss Confederation. The question that has been asked is as follows. Does the suspension of air transport represent a sufficiently well-grounded reason to determine the extent of public custody against X? There are two opinions which have emerged from the judicial decisions of the empowered courts of appeal in Romania. In the first opinion, the court rejected the request of the competent authority to extend the duration of public custody, assessing that the suspension of air travel to the country of origin of foreign citizens does not represent a sufficiently well-grounded reason to lead to the extension of public custody. For instance, it has been rejected the request of the competent authority to extend the duration of a public custody in opposition with a citizen of Egyptian origin who had crossed the state border illegally for the reason I mentioned before. This example is quite interesting because there was another case with the same example, an Egyptian person who illegally crossed the state border, but for whom the court admitted the plaintiff's request to extend the duration of public custody, assessing in this case that the suspension of air travel to the country of origin of foreign citizens is a founded reason. So the examples which I gave are quite identical, and the court has had divergent opinions on it. What were the arguments, the court's arguments when analyzing each of the aforesaid cases? First of all, in support of the first opinion that rejected the request to extend the public custody, it was noted that the flights to the country of origin of the foreign citizen were interrupted due to the situation generated by the incidence of the spread of the COVID-19 virus, and that, and I quote, "Given the total uncertainty hovering over the moment of the resumption of transport airlines to the country of origin of the defendant, the extension of the public custody measure would not comply with the requirement provided by Government's Emergency Ordinance number 194 per 2002. In addition, the court held that the plaintiff requests the extension of public custody for a very long period of time, namely 5 months. And from this, it follows that the return of the defendant is not seen by the plaintiff as concretely possible within a reasonable period of time. Moreover, the court argued that the claimant has at his disposal administrative measures less restrictive than custody that would allow the return measure to be carried out at the moment where air transport to the defendant's country of origin will be resumed, such as establishing in charge of the defendant the obligation to appear periodically at the plaintiff's headquarters, the obligation to announce any change of residence, etc., this being in accordance with the requirements of the Directive 2008 per 115 of the European Parliament. In fact, it was noted that taking into public custody it's only an exceptional measure that is ordered only if other sufficient measures cannot be effectively applied. The court deeming that the granting of tolerance could represent such a measure. The provisions invoked by the court of the Directive 2008 and retained in other similar cases provide the following. Unless other sufficient but less coercive measures can be effectively applied in a specific case, member states may hold in public custody a third country national who is subject return procedures only in order to prepare the return process and to carry out the removal process, in particular if there is a risk of evasion. So even the article invoked by the court, and I must emphasize that the article stipulates that if there is a risk of evasion, I could not let a foreigner free. I must put it in public custody until I can remove him from the territory of the state. In my opinion, the situation of a foreign citizen who tried to fraudulently cross the state border of Romania, it cannot be appreciated that the granting of tolerance would be a measure that can be effectively applied. The conduct of such a person unequivocally indicates the intention to evade the measure of removal. The removal of the foreign citizen from the accommodation center could lead only to the encouragement of this foreigner to attempt to illegally cross again the state border, to try to reach another state that, in his opinion, would give him many more opportunities than Romania. In addition, the imposition on the foreign citizen of the obligation to present himself periodically at an interval of 2 months or whenever he is called to the structure of the general authority does not represent any guarantee that he will comply with the duties established in his regard. Nor the argument according to which the plaintiff requests the extension of public custody for a very long period of time, namely 5 months, cannot be considered a valid one, taking into consideration that, according to the law, the period of detention in public custody of foreigners against whom the measure of return has been ordered cannot exceed 6 months. So we have 30 days that are given by the prosecutor's ordinance in order to return the foreigner, and then we have the possibility, according to the law, to extend the public custody for another 5 months. So there is a total of 6 months that the authorities can use in order to remove a foreigner from the territory of Romania. Of course, even though it would be admitted for a period of 5 months, the extension, this does not mean that when it will be possible to return the foreign citizens, the return decision will not be enforced. So if after, let's say, 1 month, all the formalities are completed, the foreigner will be returned. He won't be held in public custody for the total period of time. I would like to emphasize that if the court were to consider that the period for which the extension of public custody was requested is too extensive, the court has the possibility to admit the request in part for a shorter period. In conclusion, regarding the suspension of air travel to the country of origin of the foreign citizens, in accordance with the majority of points of view regarding this topic, I appreciate that this is an objective reason which does not depend on the will of the competent public authority with the removal. And in support of my opinion, I would like to highlight as an example that throughout the judicial decision, the empowered Court of Appeal admitted the request to extend the duration of the measure of public custody against a foreign citizen, noting that, and I will quote, "In the case, it is found that the defendant could not be removed from the territory of Romania in the term provided by law due to the cancellation of flights to Egypt as a result of the epidemiological situation, according to the documents on file." Also, by way of example, throughout another judicial decision, it was held that since the defendant MW does not have financial means and their flights from Romania to his country or origin due to the COVID-19 pandemic, the escorted removal measure ordered against him cannot be enforced, so the request to extend the duration of the measure of public custody is justified. To sum up, in my opinion, the suspension of air transport represents a sufficiently well-grounded reason to determine the extent of public custody against a third country national who unlawfully crossed or attempt to cross the border, being caught staying illegally. This was my presentation. Thank you very much for your attention, and I hope you found it interesting.
So, thank you so much. And now it's the time to open to the Q&A to our panel. I will usurp already my position as a chairperson, and I will start in order to break the ice. So Beth, I want to thank you so much for the very interesting presentation. But what I want to ask you, despite the fact that you try to look for a broad definition of administrative law, it seems to me that normally the administrative law is a combination of administrators that were democratically elected directly or indirectly, and administrators who are more professional. And what it seems to me, without thinking too much, long enough in my opinion, on your interesting proposal or perception, is that what you are doing is to take the rules which were developed in administrative law in order for the professionals to work properly, smoothly, efficiently, and telling us that all these rules are, as a matter of fact, have a democratic deficit. So even the fact-finding, we start with the idea that they are more professional in order to find the facts, and then you say, but eventually, cost-benefit analysis and all that. So clearly, administrative law has a problem of democratic deficit, if you want, because the whole idea is to facilitate the administration of the country. And by, unveiling piercing the veil and saying that, well, these are problematic norms or part of administrative law, it's correct, but at the same time, that's the compromise already done by establishing or making the administrative law to balance between efficiency and democratic accountability. That's one question I have. I might be wrong because I didn't think about it until it. And the other question is, in your proposal, how to amend, isn't it one better, except, the fact-finding is a good example, but it's a very, very important one because everything is based on the facts, but it's still a very limited one. Why not to do away with the, if you want, I don't know how you say it, the legality principle that the administration is doing whatever it is done is legally, and presumption of legality, that's exactly. And shifting the burden of proof to the state rather than to the individual on a more general way, saying whenever I go to the court and I manage to show that there is some hint of a problematic measure on the basis of the administration will need to reason and justify their provision, and maybe that will make it more easy. Of course, judicial deference to the administrative, that's another way, but just maybe that's the one thing. So if anyone else has to Beth questions, maybe. Yeah.
I want
sure.
Just to complete what you have just said, because the shifting the burden of proof will automatically be done if we characterize the administrative as criminal in the sense of Article 6 European Convention of Human Rights, which is more and more the case with administrative proceedings leading to harsh penalties.
Okay. And Beth, before you answer, you want to hear to Beth, or you want... No, afterwards. So you answer first. Sorry.
Okay, thank you for these questions. Well, this is actually what this whole article is about, that experts, or at least public law scholars and people who are concerned or are knowledgeable about administrative law start asking these questions and start reconsidering why did we have them in the first place. So that's one thing. So regardless whether you agree with my position or not, it's at least a thing that we have to be sure of as administrative lawyers. Now, as to the presumption of legality, the problem with the presumption of legality is not necessarily that the presumption of legality is there when you argue your case before the court. So it's not so much, the problem is not so much the burden of proof that is with the citizen, because in practice it's a bit on both parties, typically in an administrative law case. So so the court doesn't accept, an administrative law court doesn't accept the presumption of legality. No, it is until you are in front of the court, there's the presumption of legality, which means, like the example given also by the ombudsman, so if you're my political opponent, which of course you're not, but I want to just make life difficult for you, I refuse your economic license. Or I issue an economic license, I do a tender. You do a tender, then I give it to her. That tender, which I gave to her, is already legally valid, although it's totally unlawful, but you have to wait till have your successful claim before a court. And that's maybe 2 years later, and then you're out of a bit. Yeah, but
in order to contest it, at least in Romania, it's...
Yeah, but even if you contest it successfully, and even if the burden of proof would be with the administration, you're already 2 years away. But I do not want to get rid of the burden of, but the problem is I do not want to get rid of the presumption of legality, because it also operates the other way around. Imagine that I grant you a permit, and I do it perfectly lawful, and the permit is lawful. What would that mean? That you then first have to go to a court to have an administrative court validate that permit? That would make life impossible, and citizens would not know what to rely on. So the presumption of legality is in and of itself not something that I would like to contest, but you have to realize what the consequences are. It's a bit like fire. You need it, or gas, we need it, but it's risky. By contrast, judicial deference to fact-finding, I don't see the reason. One of the common sense logic between judicial deference to fact-finding is, well, if the administration has some discretion, and they have discretion in fact-finding, because I cannot show this slide, but there are facts which are not precise facts. So it's not about the age of a person, but it could be, for example, market share. So if two companies want to do a merger, they cannot become too large a company because then they have a dominant position, and so they have to determine the market share. But that's not a thing you can measure precisely. Those are estimations. And so there are multiple reasonable estimations of what the market share of a company is. And there the state or the administration has discretion. It has this choice, the liberty to choose between reasonable estimations. And then the thing would be, and then of course the judge cannot replace, if the fact-finding is reasonable, then of course it's not up to the court to come up with his own reasonable version. And I disagree. The reason is because the court cannot take the place of the administration, or the administration knows better because it has much more experience. But that's not what we do in civil law. We have very highly technical, difficult cases in tort law, in medical malpractices. Yeah, but you have also experts in administrative law courts, so that could be. And the funny thing is, because one of the reasons, the rationale behind it was on the slide, is that, it's the kind of which you have in a relationship, right? So if I ask my girlfriend, my wife, we're not married, but my significant other with whom I live together, if I ask her, okay, could you find a thing what we will do tomorrow, and you select a thing or a restaurant, and says, yeah, okay, I found this restaurant. And it's that restaurant? Okay, let me do it. I will cancel that restaurant, and I will book it. And then, of course, people say, well, the next time I ask my girlfriend to select a restaurant, she say, well, boss, thank you, but you do it yourself. So it will immobilize her, right? That's one of the arguments. Well, that's not happening in practice. Well, in our relationship, yes, but that's not happening when it comes to law, for example. You have appeal courts doing a full review of points of law and fact-finding by the first instance courts. Our first instance courts now say, well, you know what, I'm not doing anything anymore. We have it in tort law. Tort law, okay, but then I stop. Tort law actually says that if I act carelessly, and with my act I cause damage to Tudor, I have an obligation to pay him. But it's only after the fact that it will be established, not marginally, but really established in fact, whether or not I acted carelessly. So that means that I will stay at home then, because I will not move anymore, I will do nothing anymore, because I always run the risk that ex post factum, a court will diligently find out everything what I did wrong. Oh no, I will do nothing anymore. It's not true. So the whole notion that factual discretion, which I'm not against, necessarily leads to judicial deference to fact-finding is a common sense logic which is not true and is not empirically proven. So that's why I think we should take up the fact-finding thing, because most of the cases are about fact-finding. And I'm not against policy discretion, that's fine with me. So it's not a problem, so that's my answer to your question really. It's not about the democratic deficit, that would be policy discretion kind of thing. It's a problem of law. Good old juridical law where courts do their job. That will be mine.
Thank you so much. So now to Cosmin. So I really apologize because it was difficult for me to follow. I hope the audience managed better. But I would ask you, what are the relationship between, so how do you define the relationship between exception and emergency? So if you need to. So not every exception is an emergency situation, but every emergency situation is an exceptional case, or not necessarily. That's one question I have. And the other one is the COVID, for example. So I'm sorry to bring it down to practical questions. So COVID is an exceptional situation or is an emergency situation, or how do we deal with it? Now again, if the audience don't have a question to Cosmin, or the panelists, whoever you want, then Cosmin, the floor is yours.
Okay, yeah. So I think, no, thanks for this. This is quite tough. No, well, it shouldn't be. It's not a very difficult question at the end of the day, because exception is a concept which developed out of the existence of emergency. Yeah, I think the emergency is a sort of a legal, constitutional proof of the existence of exception. Yeah, and it has been built on that. I mean, it's slowly started to develop on that, and it has been theorized because it was really the crack that Carl Schmitt saw within, let's put it this way, liberal legality, but, with all the caveats, because it's, so it was really the sort of a crack that he was able to see there, and he saw, well, actually, this is the thing. It's not a marginal problem of the legal system. It's not something which just happens through a decree, but it's something more than that. Actually, through emergency, you can see exception. So, I mean, exception is really built through that. If there wasn't any form of, historical, legal, written or, practiced emergency, we wouldn't have been able to have a concept of exception, yeah? But the concept of exception is really, it goes beyond that. It really goes beyond, because, and I think this is the particular excess attached to the concept of exception, because it enables it enables to understand a different form of legality. Legality not being found, not being grounded on, let's put it this way, on a Zolan, or not being grounded on normativity or a sort of a normative imperative, but being grounded on a decision. And then, basically you have John Austin, more or less the same theory. You have the sovereign who just puts the law, and that's it. Now, the other thing that I want to add to this is that Agamben sees it even further, so takes another step. And then the other step being that basically exception, it is just a form through which any form of politics, not only law, because he would say that law is just another form of politics, but any form of politics, anything that can give form to life, this is the mechanism through which life, Zoe, enters in, gets a form, and it becomes bios. So it has something which has a form. Now, I just find that as interesting as it is philosophically, I think it's very strange as a sort of a legal historical concept, because at the end of the day, it just simply mean that we had always been living in a continual exception since Aristotle, which is fine for a sort of a historical, for a sort of a philosophical statement, but it's just too broad, because basically I think that there are some important things which emerge around modernity, and that's why I ended up with that quotation from Walter Benjamin, which brings in the question of the advent of market economy, because I think that there is something, this sort of specificity of exception, it's something which emerges or it becomes visible only in modernity. Yeah. Now, COVID. I think that COVID, and this is my own position, have to look at it from two perspectives. I mean, on one hand, I really think it was an emergency, a medical emergency. That's why I think Agamben failed to grasp it, because Agamben, he was all too caught in his own sort of, sorry, I don't want to offend anyone, but in some sort of a paranoia about, but he wasn't even able to understand in his own terms COVID, basically. I mean, so I think this is also very interesting, because at the end of the day, it shows on one hand the limits of the concept of the exception. His own, I mean, his book on I don't have the title now. I think it was like something like on biopolitics, or politics, stanze sulla politica e COVID, or something like this. He doesn't really even try to understand what's going on with COVID in terms of medical terms and so on, because it's always about biopolitics. So it is always about power and over life. But this relationship between power over life, I think even philosophically, it's a bit more complicated, because it's not about, I mean, what we had with COVID, we had a medical emergency. Now, there are some problems. The problems are, and then I'm going to stop. The problems are that COVID came at a time when we already had experienced a number of permanent states of emergency. So then the question becomes very problematic, because from that moment on, I think what became, and that has created a lot of problems, driven the anti-vax wave and then so on and so forth. It was precisely this sort of incapacity or inability of thinking a purely medical emergency outside the structures, because the structures of emergency have been sort of, and we saw it in Romania, they have been militarized, security related, and so on and so forth. And I think that in many respects, one of the failures of our responses or legal responses to COVID were really to catch that medical dimension and to remove it from the sort of history of, the uses of emergency were either in economy or in policing, or, broadly speaking, security measures. And that sort of, with the history that we used to have, it created a lot of problems. But I would say that COVID was an emergency. It wasn't like really, it was perhaps a clear emergency. It was an emergency in a sense, a very, very real one. Yeah, it wasn't a legal emergency, because in many cases, legal emergencies are just created legally. They are kind of, created by the declaration of being there. Whereas, that was a virus which was spreading, so.
Yes, thank you so much for thinking on your feet as well. That's really great. So my next question goes to Tudor, and that's in a way emphasizing the exceptional. So what we want is the law to apply to everyone in the same way, and therefore that that the criminal law will apply in the same way to everyone. But then it seems to me that it often, when there is a question of criminalization of the elite or the politicians, it's taken, then we really concentrate on the fundamental rights, and then, to have a law which is precise, not to interpret it against the accused. We don't really are so precise according to, as you said, Article 6 and the due process when it's the normal criminals. And therefore, maybe we need to think about an exceptional criminal law for these cases of elite. I don't know how to define it, whether elites or politicians who are criminalized. And in this way, for example, like asking ourselves whether the right to remain silent is also a right that we want to give to any accused, but also to politicians that is accused about something which is going in part of his on his power, just as in one example, but some of the examples that you gave are maybe telling us that we need to maybe differentiate also as and the right of privacy. So there are certain constitutional rights that we differentiate between elected persons and normal people, and maybe we need to think about. I mean, it's against my views, but I still wonder what your take about that.
Actually, my view is perfectly contrary to yours. So I think, at least in the case law of European Court of Human Rights, politicians are not humans. So they have less rights than the average. If we took the same example with the prohibition, if this prohibition or this kind of procedure, the sanction, actually, will apply to a chief prosecutor, for example, it would be a clear violation. Like it was in Kövesi case. Yeah, so she was dismissed, not due process. Here, inadmissibility, because if you get this prohibition based on the fact that you got an elected position, you are not getting into neither the civil limb, neither the criminal limb, and you are between chairs, as we say. So between two stools, as the English expression was. So I think, and it's an old idea of mine to write an article that for the European Court of Human Rights, politicians are not human because they are not granted the same, yes, as an ordinary citizen. But we can develop this discussion.
Thank you so much. And Silvio, last but not least, so I understand there's a COVID, there's problems. Why is it always that the state should privilege from this situation rather than the refugee or the one claiming refugee status? So it's misfortunate that the state cannot push him back because there are no flights. So maybe the consequence is that he stayed 5 more months. I understand not necessarily, but or even more. Let's say it's even correct. So at a certain time, he remains here, or he or she remains here, because it's not his or her fault. I understand it's not also the fault of the state, but the state has better shoulders there. It's much more powerful to accept this the exceptional emergency situation and then somehow internalize the problem, rather than shift it back to the immigrant and tell him, well, now we didn't manage until now, but now it's the time, so we do it.
Okay. So as long as the foreigner has a return decision issued on his behalf, as long as that document is it stands, it's not annulled by the court, even though the foreign citizen will be granted the tolerance on the territory of Romania for an undetermined period of time, of course, until the flights are back or until all the procedures are completed. It will be tolerated, but in the moment in which he or she can be sent home, he will be sent home.
But there is a time limit. There are limits also for
Yes.
the state, but it couldn't fulfill the time limit. Too bad for the state. Why it should
the-
be too bad for the immigrants? So
the
they
time-
need to do what they need to do in
The
state.
time limit regards the period in which the foreigner can be held in public custody, so in an accommodation center. After the time limit expires, you'll tolerate the citizen. He has the obligation to tell the authorities where he can be found, where will he be located at any time, and at the time when he could be sent home, he will be sent home. So the limited period of time refers only to the period in which the foreigner can be held in public custody.
There's no time limit for validity of this kind of decision?
No,
in order that-
that is legal. It stays legal until any court says something different.
So he needs to apply to show that there are different circumstances that doesn't justify to send him back. Otherwise,
Yes, yes.
I am problematic with anyway. That's me. Thank you so much. Any more questions from the audience? So without further ado, because we are already 1 hour and a quarter past the time that was dedicated for this conference. Thank you very much. Please join me in applauding all our speakers, and I wish you a wonderful rest of the day.